7 o'clock, so we're gonna call the meeting to order. We're gonna do a roll call. Larry?
Here.
Matt?
Here.
Stacy? Here. Travis?
Here.
Mary?
Here.
Was the meeting properly noticed?
The meeting was properly noticed.
So before we adopt the agenda, we are going to look to table under new business, item A, Cooperative Educational Service Agency contract. I don't know, Mike, if you want to speak about
Yeah,
that.
we, in preparing for today, we identified that there were some issues with that contract, so we would look for a motion to amend the agenda to table that to the June 23rd meeting.
Okay. I will move to table item, let's see what it is, 8A, Cooperative Educational Services Contract for the 2025-26 school year until the next meeting?
Yes.
Okay.
Second.
All in favor?
Aye.
Abstain.
With the amendment,
So then you'd seek a motion to adopt the amended
Adopt the
agenda.
Then I'll move to adopt the agenda as amended.
Second.
all in favor?
Aye. Aye.
Any opposed?
Oppose.
Let's stand to do the Pledge of Allegiance. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
have any salutes and recognitions.
I have some, just to salute and recognize some of the end-of-year activities we had. The commencement that was on Saturday, I thought the timing was great. It looked like we had really good attendance from the families, and it was a great ceremony. And then the ASA on the football field, it is just done really well, I think, and efficiently. And then the end-of-year event where we salute the retirees, and just Mike is able to summarize the year for the staff. And I want to point out, he just did an awesome job acknowledging that we're going through a dark time right now, but that the light always overcomes the darkness. And he said, you know, we are not ignoring it, but we are going to celebrate today all of the good things that have happened this year. So it was a really great celebratory morning.
Anybody else?
So Tammy, I need you to fill in the people on those events for me, please. Thank you.
Yeah, I just would like to really in particular salute our four principals for the work that they did, just wrapping up with the exception of some of the things that we're dealing with right now, a very good school year. Just a lot of things to be really proud of. I think there's a lot of progress that we continue to make, and I think we're fortunate to have the leadership that we do at those buildings. So I'd just like to acknowledge our four principals for the work that they did, along with their teams, to lead to a really nice finish to the year.
I would echo that, as well as the school resource officers. Been on work lately.
Very much so.
Yeah. Anybody else? Comments from citizens. Tammy, any comments from citizens? There are no comments from citizens. Okay. We'll move on to the open meeting law requirements presentation.
Yeah, I'd like to introduce Brian Waterman, one of the attorneys that we work with. And if you recall back to our planning session in February where we had our little retreat, one of the items that was on my to-do list that was requested from the board at that meeting was to have a little bit more learning on open meetings law. So I invited Brian to be here and to do a little bit of a presentation to you. You have materials that he provided that I passed out to you. And then, so he'll walk through those things, and then is available to questions that you have. So Brian, thanks for being here tonight.
Great, thanks, Mike, and glad to join everybody tonight. I think it's been a few years since I've been with the board on this topic, and I like to say that, I really, oftentimes when school boards are seeing me outside of annual meetings, it's usually because there's a problem or, difficult decisions to be made. But this is a great opportunity for me to spend some time with you guys and, talk about some workshop items. I do this a lot with a lot of different boards, and we talk about all kinds of things, board ethics and liability and public records and that type of thing. And tonight we're going to be really focusing on open meetings. And the reason I like talking about this kind of stuff is because it really empowers you as board members to make sure that you're complying with the law, but also doing the job the best you can. And I really respect and honor the work you guys do as board members. So I feel like by spending that time with you and answering questions, hopefully we're equipping you guys to do the job that you were elected to do. As Mike said, I do have some materials here that are in front of you. There's about 10 pages of an outline. We're going to follow it loosely. Feel free to stop me and ask questions. That always makes it a lot more interesting. Real world experiences that you've had, I'll share some of mine. And I'll leave some time at the end for that as well. But this will also act as a bit of a resource for you, so that you can go back and take a look at it if you have questions. Then, of course, if things come up, work through Mike, and I'm happy to handle any issues offline outside of this. So we're going to start off. One of the reasons that open meetings is so important is because not only is it important to government transparency, but really in the last several years, you've really seen a higher level of scrutiny for school boards with regard to their open meetings. Some even to the point where it's been weaponized for political purposes, and some just out of good faith curiosity and oversight by the public. And that's really the purpose of the open meetings law, is to ensure that the public has access to be able to see what their government officials are doing, what their government bodies are doing. So the two key principles are that it's accessible to the public, all meetings are accessible to the public, and they're open to all citizens. And we'll talk a little bit about what that means. But in general, you should understand that the open meetings law, like the public records law, has a presumption of transparency. So the legislature, not just the courts interpreting the law, but the legislature in the statutes itself has indicated that it should be liberally construed. So when we're looking at exceptions, for instance, we'll talk a little bit about what it takes to go into a closed session. That's to be narrowly construed, and the presumption is one of openness. And so you see some of those concepts there at the top of the second page when we talk about the policy of accessibility and openness, when we talk about all meetings preceded by public notice and initially convened in open session. And then again, doubts should be resolved in favor of openness. And so I want to talk a little bit about some definitions that kind of set up the discussion, because when it comes to the open meetings law, those definitions are really important. So we ask questions like, who's subject to it? The board obviously subject to the open meetings law, but what about other types of things? So for instance, committees or even advisory task force that might be set up. All those kinds of questions are defined in the law, and the statutory definitions can help us. So if you look there in the middle of page 2, when we talk about what is a governmental body that's subject to the open meetings law, it's really, as it says, boards, commissions, committees, etc., that are created by constitution, statute, ordinance, rule, or order. So really you're asking, when you're talking about who's covered by the open meetings law, you're talking about what authority created the body and how did they create it. So was it by rule, was it by order? And again, we kind of take for granted that a school board, of course, is subject to the open meetings law, but there are other entities, things that task force that you might create, or subunits of your body that would be included as well. That includes committees and others. What's a meeting? When you think about what a meeting is under the open meetings law, really you want to ask two questions. What's the purpose of the meeting, and what are the numbers that you have, whether you have a quorum or not, or enough people to determine the course of action for that body. And so that's how we define a meeting there at the bottom of page 2. Spilling over onto page 3, you see we talk about the number of members present. So 1/2 or more, a quorum is going to be considered presumably that you're conducting business. And that becomes important when you're talking about perhaps social events or gatherings. Graduation is a good example, right? So if a majority of the board members show up for graduation, there's a presumption, even though we know business isn't going to be conducted, there's a presumption that it may be. And so oftentimes school boards will have that posted, that there may be a social or chance gathering that doesn't constitute a meeting, and to the extent that it does constitute a meeting, that gathering is not going to be something where district business is conducted. You see that all the time at sporting events and various things where board members want to participate. We also talk about the concept of a negative quorum. So I mentioned that it's not just having a quorum, but it's really any number of members who can control the course of the body. And so in the rare circumstance, for instance, that you need a supermajority vote, which once in a great while happens under certain topics, then even that negative quorum, that if it's required for 2/3 of a vote to pass something, and only 1/3 are present, that would be considered a negative quorum, and you would constitute a meeting if you're there to do business on behalf of the district. When I talk about business on behalf of the board or within the board's jurisdiction, yes?
Could you do that again? The 1/3, 2/3?
Sure, so it's called a negative quorum. So for instance, if you had needed a supermajority, which is typically 2/3 vote to pass something, and instead you had 1/3 of the members who were going to show up at that meeting, even though it's less than a quorum who might show up at the meeting, if what's on the agenda that evening, you have enough to shut something down that would require a supermajority, then you would have a quorum, and it would be a meeting, even though you have less than a majority. I've personally never seen it happen, but it's a concept in the law we talk about, just in case.
Got it. Three board member meetings, three member boards. What does the open meetings law do to those?
Sure, so it's the same concept, it's just applied to whatever that body is. So for instance, if you have committees, right? Committees that have 3 members, if you have 2 members who are meeting somewhere and discussing board business that's within the jurisdiction of that committee, that would be considered a meeting that needs to be posted.
Right, but the presumption business, so if I pick up the phone and I'm making a phone call to one of the others on the board, I'm already dealing with a quorum situation. So I've asked this before with other people in your profession, and I've never gotten a good answer about that. It seems prohibitive to me that if you are a board of 3 or a committee of 3, according to our laws, you can't talk to each other unless you've announced it 10 days prior.
Yeah, and in my opinion, best practice at least is that you should not. So if you're a committee of 3, you shouldn't. I would advise against picking up the phone and talking about a matter substantively, not whether something should be on the agenda or your availability for a meeting, for instance. But substantively, I would avoid discussions from 2 members of a 3-person committee.
I would just push back. How does that even work? If you can't talk to one other person and you're just a committee of 3, it seems like a non-starter. Nothing's going to happen. Nobody can talk to each other about the agenda. Nobody can talk to each other about what should be discussed.
No, again,
because it immediately becomes entity subject to open meeting laws. So I put that back to you folks. I guess you're not in the legislature. You're just an avatar for them. But I've not seen how that works. I've not seen anybody have a good explanation for how that works. And what it has the effect of doing is tamping down conversation among people who should be talking to each other. We do not have that in administration, where a lot of things happen. Administration can talk to each other all they want. Nobody gets a record of it. Nobody knows what's going on because they're not subject to the same meetings. They can talk one-on-one. They can talk 5-on-5. But the way it's set up and the way, as I understand it, the Attorney General has made part of the record his opinion that XYZ flows from what the legislature said. And I see everywhere that it is having a massive effect of nobody's talking to each other on the elected level. Thanks very much.
But,
yeah, and, I mean, you raise a good point in that it creates a challenge. But I think the legislature would say that's the point, is that those conversations can happen, but they need to be happen at a properly noticed open session of that committee. Things like talking about whether or not something should be put on an agenda, again, non-substantive items, or whether somebody has availability for a meeting time, those things can be discussed. That wouldn't be considered to be a meeting because you're not talking about a substantive matter. As soon as you start talking about those substantive matters, I think that's where it kicks in. But yeah, a lot of people are frustrated that they, especially in the small group setting on the committee level, that they can't have those conversations. And
Right.
Again, I think the legislature would say that's the purpose of it, is that they don't want people who can make decisions on a certain body making those decisions, discussing those decisions outside of a properly noticed meeting.
I understand the intent, but the effect of it is quite chilling. The Attorney General's opinion on this has in writing that even the appearance of a possibility that you could be talking business should be avoided because it would be against the open records law. So that my picking up the phone and calling another member on a 3-member committee, that falls under his description of, well, that has the appearance of. So again, it's a chilling thing.
I'll move on, but I will say that, again, it's a challenge that I think you see. But I also think that the Attorney General's opinion, based on the legislature speaking through the statute, suggests that that's the purpose, is that we don't want to have those kind of conversations outside of the properly noticed meeting. But that is a good segue to a walking quorum. Like, so you've probably heard the term a walking quorum. A walking quorum is essentially a polling of various members. So while you might not have members speaking together that are a quorum, you go person to person and ask what their opinion might be on something. And if there's agreement there by a quorum of the members, you could have an illegal walking quorum. So, again, the old thought was you pick up the phone and you start talking and you ask somebody how they feel on an issue that's before the board. And then you go to the next person and you ask that, and pretty soon you have an idea of what that vote's gonna look like. And the law says that's an impermissible action under the open meetings law. What gets really tricky is when you talk about the advancement in technology, with both the open meetings law and the public records law haven't caught up to technology, right? There's nothing about virtual meetings. There's nothing about modern technology as far as email or text messaging and what that looks like and the impact that has. So what we do is we take the concepts under the existing law that doesn't recognize those things and we apply them to technology. And you can see at the bottom of page 3 here, we have a little bit of a focus on that. So, under what circumstances might electronic communications constitute a meeting? And I think while there haven't been court cases that have given us specific guidance, we do think there's a number of elements that the courts would evaluate. Basically, how much does it look like a meeting, right? So the number of members involved, is it a quorum? The number of messages going back and forth, does it look like a conversation? Is it in real time? So what's that time frame? Is it, if it's a letter via snail mail, that's a lot different than an instant message via text where multiple people can be in a group text. And so that's another thing that as board members you want to be wary of and be careful when you're communicating, not just for open meetings, but also for public records issues. But I think that looking at that and whether or not those communications are of a conversational tone and look like a meeting, even though you might not all be in the same place, is an important concept. Public comment period, this has been kind of a hot topic lately. I think it's important to note that the open meetings law permits public comment, but it doesn't require it. The requirement is that the public be able to observe the business being conducted by the board, not that they be able to participate in it. Now, in reality, I don't know of a single board, the school board in Wisconsin, that doesn't allow some form of public comment, but that often looks different. Sometimes it's limited to agenda items. Sometimes it's anything that they might want to raise in a public comment period. Sometimes you have it before the business of the board. Other times you have it after, or even both, or with each agenda item. So it looks a lot of different things or different ways. And the reason it looks a lot of different ways is because the law has said that generally boards have some discretion as far as what that public comment period looks like. So you might have some reasonable restrictions about time limits, for instance, and there's also oftentimes reasonable restrictions on behavior and decorum, so that, for instance, you don't have the right as a public commenter to be disruptive or disorderly or use threatening language or actions. Those are all reasonable constraints that you can put on speech during public comment periods. What you can't do is demonstrate viewpoint discrimination, for instance. You can't regulate people's speech based on the topic generally of their speech, or oftentimes even if they're addressing particular officials or public employees, and that's something we've seen a lot lately too, as people have become more emboldened coming up to the public comment podium and directing their comments at particular individuals, for instance. And how does the law deal with that, and where can the board restrain speech? And my general advice to you is especially presiding officers, is to really be careful about restricting public speech. It's hard to make those on-the-spot calls, and oftentimes we've seen a lot of litigation recently regarding those issues and those restraints on free speech, so something to be careful about. One thing to note is that the board, during the public comment period, best practice is really not to engage, right? Because especially when you have a public comment period that doesn't restrict comments to just agenda items, it's important that the board then not engage, because what you're doing is you might be crossing that line into conducting public business that hasn't been noticed if it's not on the agenda. The Attorney General has also indicated that board members shouldn't use their position, even though they're citizens and you generally have the same rights as other citizens, they shouldn't use the public comment period to raise an issue that's not on the agenda otherwise. And that's because you as board members have the ability to influence that agenda in a way that the members of the public, other members of the public don't. And so the Attorney General has indicated that would be an improper use of your office in order to circumvent the notice requirements of the Open Meetings Law. All right, we're going to talk a little bit about closed session on page 5. I'll be mindful of my timing here so I don't go over. So closed session, unlike the public records law, which has a balancing test and things like that, where you might find exceptions elsewhere, the public records law, its exceptions to open meetings and the ability to go into closed session is really, it's strictly defined to what's in statute. And so we talk a little bit about some of those exemptions in a moment, but first let's talk about the requirements, right? So it has to be agendized, just like other topics that you're going to talk about. There has to be an announcement of the intention to go into closed session. There has to be a motion and a second and a roll call vote, and that all has to follow an explanation of what exemption you're going into closed session under. And then once you get into closed session, after a majority vote approves it, you have to strictly stick to the reasons why you're in closed session. And this is one of the biggest difficulties I see for boards, is that they go into a closed session and there's these topics that they're talking about are very complicated, and there's lots of overlap with other issues. And if it's not agendized properly and you're in a closed session, sometimes that can be restrictive if you actually intended to talk about other things that were related to it, but it's not agendized for that. So it's something you really want to be careful about, both when you're creating the agendas, in consultation with, of course, the administration who puts those together, really being clear and communicating about what it is your intention is to talk about during that closed session so they can agendize it appropriately. And then also, once you're in that closed session, to make sure you stick to that topic and things that are closely related to it.
Brian, are you saying that in our motion, or like in our discussion of going into closed session, we have to acknowledge what we're gonna talk about, or just in our agenda, as long as it's listed in the agenda?
Best practice is that it be part of the motion.
Okay.
So you identify the exemption under which you're going and we'll talk about it in a little bit here, give a general description. And usually that'll be in your agenda already, to say, this is the purpose for which we're doing this. Now, you don't have to be so specific that it jeopardizes the reason for going in. So for instance, if you're talking about a specific employee matter, and we'll talk about that as one of the exemptions, you don't have to identify the employee by name, right? Because that would jeopardize the very reason, the confidentiality for going into closed.
But I mean, Stacy, your question is a good one, but it has to be one of the specific categories in that 19.85, whatever it is, A, B, C, D, based on his information there too. I mean, it's gotta be that, at least referencing that particular section of the statute.
Yeah, exactly. It's got to be identified. So let's talk about those exemptions. At the bottom of page 5, you see where we've got a summary of them. The first one, judicial or quasi-judicial matters. So think of that like expulsion hearings, when you're operating as decision makers in that regard, kind of a quasi-judicial arrangement. Considering dismissal, demotion, or discipline of a public employee over which there is jurisdiction. Similarly, on the top of page 6, we talk about considering employment, promotion, compensation, or performance evaluation. Now, the important takeaway here is that it's got to be a specific employee. And so oftentimes, boards want to use this exemption as a way to talk about policy issues that might apply to employees in general. And the Attorney General has said that that's not a proper use of that exemption. It really has to be, now it can be more than one specific employee, but it has to be specific employees that you're talking about with regard to promotion, compensation, performance evaluations, et cetera. The next one, competitive bargaining reasons. So deliberating or negotiating whenever competitive or bargaining reasons require a closed session. We just recently, I think in February, had a Court of Appeals decision that was very important here. This is often used for things like negotiation strategy over vendor contracts or collective bargaining with the teachers union. Those are the things you often see this used for. The Court of Appeals in February issued a decision that said that, again, along the lines of maintaining your discussion strictly to the exemption, the court held that at least part of that discussion needs to be in open session. Before you go in, you need to explain what are the competitive bargaining reasons, right? So the public has an understanding of what those reasons are. So in the past, where we might just say, well, anytime we're discussing anything related to a vendor contract, it's for competitive bargaining reasons, the court said, and some think this is a bit of an overreach, but the court said that prior to that, before you vote on whether to go in closed session under this exemption, that you should identify what those competitive bargaining reasons are, and then stick only in your closed session to discussion of those competitive bargaining reasons, not all other aspects that you might be discussing. So really talking about strategy, for instance, rather than general terms. The next one is used quite a bit, potentially damaging information to reputation. So considering financial, medical, social, personal histories, again, of a specific person that are likely to have a substantial adverse effect upon the reputation. So you'll see this a lot when we're talking about investigations or other information about either members of the public or complaints that have been filed against people, when there's potentially damaging allegations that could do harm and that hasn't yet been proven, but you want to do some initial consideration of that. And then the final one there, conferring with legal counsel. Important to remember, not just having legal counsel present, that's not good enough. It really has to be that the legal counsel is rendering oral written advice with regard to strategy for litigation that the district is likely to or is engaged in. Now, whether you're likely to be involved in litigation, that leaves a lot of discretion there and debate over whether or not that's the case. But the key is that you have to be talking about strategy to be adopted by the board with regard to that litigation, not just any general topic you want to talk about with an attorney in the room. Any questions regarding those closed session exemptions? Okay. Reconvening into open session. So this is an important component. You can adjourn right from a closed session. You can adjourn a meeting. But if you need to take action, for instance, if that's not posted in your agenda, you can't come out of close and take action within 12 hours, as it says here. Simply because what the legislature was trying to avoid is a circumstance where you go into closed and no one knows whether you're coming out. Maybe the board's meeting late into the night, and the public just doesn't have any notice that you might come out of closed session and actually do something that pertains to the closed session matter, and they have a right to notice regarding that action that might be taken in open session. So an important part when we're talking about agendas. A question I often get is, when is it okay, if ever, to vote in closed session? And the answer is, under certain narrow circumstances, it might be. And really the key point here is, if you're going to vote in closed session, it can't just be for convenience or confidentiality purposes that aren't related to the closed session itself. So for instance, if a board is worried about saving face on an issue or that type of thing, again, out of convenience, that's not permissible. But what is permissible are the rare circumstances when the very vote that you're taking has to do with the reason why you're in closed session in the first place. And to vote in open session might jeopardize that confidentiality. So it is permissible, but it should be used sparingly under only certain circumstances.
Could you give an example?
Expulsion, again, is a good example. So expulsion, not only do you deliberate in closed or executive session, but then you also take your vote because the reason for that confidentiality would be jeopardized if you went into open and voted.
Yeah, aren't expulsions, they're open or closedness at the discretion of the expellee?
I've only had expulsion hearings in closed session. I've never done an open expulsion hearing, and I don't believe that would be permissible.
Thank you.
Sure. Confidentiality. So a lot of people are surprised to learn that there's no law, and the open meetings law included, that says it's illegal to discuss closed session matters outside of a closed session. And the reason that people often don't realize that is because it's such an important principle when it comes to closed sessions and confidentiality. And I can say that most boards, and I'm sure yours is no exception, have policies that require the confidentiality of closed session discussions, even if it's not required by law. And so I can say from experience, nothing erodes the trust among board members faster than leaks from a closed session. So even if permissible under the law, even if it weren't in violation of your policies, which it likely is, as it is with most boards, it's really detrimental to the cohesion, the credibility of the board as a body, and again, nothing erodes that trust and that confidence among board members faster. So it's an important principle that I would advise. I'd also say that there is the potential for liability in cases when you're talking about, for instance, employee situations. If you're talking about an employee medical situation, or you're talking about a confidential student matter that's protected by FERPA. If you were to leak that information, there is the potential that a third party could bring a lawsuit if that information leak somehow was damaging to them. So there is, even though it may not be illegal, there are certain circumstances under which leaking certain information outside of a board meeting, a closed session board meeting that is, could result in legal liability.
So Brian, quick question. Is there any sanctions in terms of if a board member does do or leak that information out?
There might be under your board policies. So most boards have a policy where that's part of their board conduct policy, and there's a mechanism involved, whether it's stated or inherently, where the board can regulate its own members based on that, whether that's by censure or removal from committees or other types of actions that they can take.
And what does censure mean again?
It's basically a public statement sanctioning the individual for their behavior and saying we don't approve of this and this is not how we want to do business, or this is in violation of our policies. And while most issues are addressed at the ballot box, and as elected officials you're answerable to the public in that way, there are certain tools such as censure and other things that board members can use to regulate each other.
Where is that found?
Typically it'd be included in your board policies. I don't know that off the top of my head, which policy it's, or even if it's there, but most districts have that.
So beyond that, it's not in law?
No, but there's certain principles that say nothing prevents a board from taking action to regulate its own members. It's just, the issue is it doesn't have a lot of teeth, right? There's no enforcement mechanism, so you can censure somebody and make that public statement. You can do a number of things that are short of that as well. But ultimately, again, those decisions are made at the ballot box by the electorate.
Thank you.
And of course, if you had mentioned someone could bring a suit, so if you were to leak something that's potentially damaging to someone, you could face damages if someone would bring a successful suit.
That's right, both
Yeah.
personally and the district as an entity.
Right.
So it can cause big problems.
Yeah.
And not just that, but also, again, the trust factor and the distraction it creates. I mean, I work with probably about 30 different school districts, most of which are in the southeastern Wisconsin area. So one of the advantages to that is I get to see what works as a board and what makes it effective and well-functioning board. And I also see the reverse of that. And I can say that the distraction caused by infighting amongst board members, for instance, regardless of the topic, can really be a distraction both for the board to focus on the business that it's trying to accomplish, but also for the administration who has to deal with the fallout of that, or the public complaints or the media inquiries and all those types of things. So well-functioning boards really trust each other. The board members trust each other. They keep a healthy control over the flow of information, so that the board, even if you disagree as board members, which you often do on issues, that the information is flowing out of the district from its official spokespersons, which is the superintendent for the district and typically the board president for the board. And so all those things are really important components to a well-functioning board. I'll skip over most of the notice requirements here because most of that applies to administration. Just understand that it's important that public notice be given it's to the public, to the news media. There's some details here on that, as well as any other notice that's required by statute. Those contents of those notices, time, date, place. The thing that usually trips up districts is the subject matter, how descriptive to be, or how general or how broad. And so, the general guidance is that it has to be in a form that's reasonably likely to apprise members of the public as to the subject matter. And that includes closed session. So the question before about, what needs to be included or stated, we really have to give the public an understanding, if not of the details that we're going to be discussing in closed session, whether it's open or closed, they have to have some idea of what it is, the general topic that's going to be discussed. And so that's an important part, and also something that's often litigated as to whether or not that description has been detailed enough and provides that appraisal to the public.
Brian, I thought relatively recently we had talked about we didn't know if it was required to post in the newspaper, but your notes say it is. So
Yep.
is that, we still,
So that's interesting, because this just came up this last week, where there was a widely issued request. It went to every school district in the state, asking a news media source, it's an online blog or something of that nature, asking to be included in the notices. And so I had a lot of districts come and say, well, what do we do about this? Do we have to follow this, don't we? And, without getting into all the legal advice, what came of that is that a lot of districts haven't been, just by past practice, haven't been providing notice to news media, which, as it says here, technically you're required to do. So it says, as it says, it's the newspaper, I think it's the official newspaper, or one that's reasonably anticipated to give notice. But I can tell you from experience, and as highlighted in the last week, a lot of school districts just aren't aware of that and don't do it. So that's an area of cleanup and improvement opportunity that I'm seeing a lot of districts say, okay, we need to do that. And it's, again, it's a bit antiquated, right? Because how many people pick up a newspaper anymore like they used to? And the newspapers never publish it anyways. They just don't publish it. And so
they don't print it?
Yeah.
It's just in their online?
Sometimes not even there,
Oh,
right? Because
really?
think about how many meetings. So the Journal Sentinel, right? Like if you're the Journal Sentinel or you're the Waukesha Freeman, and you're getting from every single governing body there is, school boards, village boards, city councils, and everyone's sending those, you're not going to post all of them. You might look at them to say, what's going on here, but generally not.
They take our money, though.
So is the because I was certain a couple of years ago there was a change where you no longer, because we used to always pay and have to pay, and the Freeman to do, well, there's some things that have to be. So there's some things that have to be, but a typical meeting. So is this saying that we have to notify them, but we don't have to pay them and buy space in their paper?
Yeah, I'd have to double check on that, but I think that's right.
Because I think there was a change a couple of years ago where you could, like your website and noticing in public places was sufficient. So this would suggest to me that we have to inform the media, but I remember it was a cost savings. Because
Yeah.
remember, we used to have the Lake Country Reporter, that went away, and then did we even have a true, and then it was the Freeman, and this was been a couple of years ago, that I don't believe we would do that anymore because it was actually gonna save us quite a bit of money, because we were paying them to do it.
So I was seeing it in the check register, so that's why I thought that we were still doing it.
So the class 1 notices that are required for budget amendments and budget adoption have to be published.
Yeah, so that's a great point, and I do believe you're right, Mike, that
Yeah.
that the law was changed where
Yeah.
you don't need to pay for it. I'm not certain of that, but that sounds familiar.
So when you, don't get off that topic if you don't mind, Brian, when you send those particular items you just referenced, those are published?
The Class 1 notices, yes, and we pay for those to be noticed,
So, well, the law's changed, so we'll let it go.
which is,
Well, yeah,
that's different than than a regular board meeting, so there's very specific, like, there's different noticing requirements, like for our annual meeting, for example, we have to there's specific noticing requirements for those kinds of meetings.
And they have to publish that.
Right, yes, so budget hearings, referendum type issues, there are separate statutes that apply there. And in that case, yes, those are different types of notices, there's several different classes of notices, but we're talking just kind of run-of-the-mill board meeting
Right,
notices.
and that made no sense. I mean, you say it, and it makes absolutely no sense that people are going to send this stuff into the papers, and the papers will decide whether or not to print it, and your first pitch to us was that was required. Goes nowhere. What would be the point of that?
Well, one,
But if the law is changed,
I'm not pitching anything. And-
That's the
and-
wrong word, but put forth
And-
to
and-
us.
And I didn't write the law, but what the law does require is that media be included with the notice, so that they have an awareness if they wanted to, that the media could post it if they wanted to. Now, what I'm saying is in practice, they generally don't unless it's one of those types of notices that's required for us to pay for them to have it noticed, and then they notice it. But generally, general meetings that we send notices for, or that we're supposed to send notices for, they don't have any obligation to do that. But the point is that the legislature said, this is worthwhile so that the media has, if they want to, an understanding that there's going to be a meeting. They have an entitlement to that.
And the Waukesha Freeman does publish the Pewaukee School District agenda meeting notices, so.
Oh, do they?
Oh, yeah, it's out
Yeah,
there.
they did when we did it. I've seen it.
What's that?
Mike got it for me.
Pardon, I couldn't hear you, Mary.
They did. I've seen it
Oh, yeah.
in
I get the
column
newspaper
form,
every day.
yeah,
So, it's published.
when we did it. Thank you.
Okay, I think I'm running short on time here, so I just want to cover another few topics. So notice timelines, just to wrap up notices, 24 hours prior to the commencement of a meeting. In emergency cases, 2 hours, that's a very high bar. There's no real definition of what that emergency looks like. I would not use that unless it was an absolute, threat to safety or decision that had to be made right away for the public safety and security. Separate notices, so you need to have separate notices for each different meeting, but I'll get to an exception for that in a second. One of those exceptions is subunits of a parent body, so committees. As you can see here under F on page 8, there are certain circumstances under which when you're having a committee meeting that might be meeting attached to the parent body, under certain circumstances, either during their recess or right afterwards, that can be included in the same notice. That also applies to committee meetings that are attended by board members not assigned to that committee. This is one that I've seen come up a lot in the last couple of years. As board members want to have information or knowledge about what's going on at a committee meeting, even if they're not at that meeting, or I'm sorry, a member of that committee, they can still show up to that meeting. Even closed sessions, they have a right to be included. And under those circumstances, when you think there might be a quorum of the full board that shows up, you have to be careful because that could turn into not just a committee meeting, but actually a meeting of the entire board. Under those circumstances, the Attorney General has said that's a rare circumstance where it might make sense to have just one notice. You don't have to notice those separately, especially if you don't know for sure that quorum is going to come to the committee, the quorum of the board is going to come to the committee meeting, but it may, or there's a good likelihood of it. And so in that circumstance, I generally say post the committee meeting and add a line at the end that says, there's a potential of a quorum of the full board, but the full board won't be taking any action or taking up any official business. I think that's good practice.
So Brian, on that one specifically, so John, if you have 4 people show up to the Business Affairs Committee, I know that we posted, but I don't know if we put that little statement at the end in terms of the quorum potentially, right? I mean, that's a specific.
Yeah, again, there's nothing in the law that says you have to do that, but the law does say that could turn into 2 different meetings, and so it's best practice to put a line like that at the end, just to cover
If it were
yourself.
just the three people there, then it wouldn't count as a quorum, but if a 4th person shows up, even they're sitting in the audience, it still could potentially have that statement then, right?
Correct. Now, again, is it a technical violation? Maybe not, because if they're not discussing something that's in front of the full board, but as a best practice, yes, I recommend doing that. And simply because a lot of this stuff is just there's a lot of gray area or gaps in the law. And so over the years, all these attorney general opinions that we could pour through, or anecdotal scenarios really teach us a lot. And that's how we get to that best practice. Because sure, if we had to argue it from a legal sense, we might be able to put up a defense, but why even get there? If you can learn a best practice from those opinions or for the anecdotal experience, you might as well implement it to even avoid the issue.
I think it goes to one of your first comments about the presumption of transparency. So you're just wanting to always demonstrate that you're trying to be transparent and very clear as to what the purpose of the meeting is, what's going to be discussed, who's going to be in attendance, what may or may not happen at those meetings. So statements like that, I think, just help with that presumption.
Yeah, and I think that goes a long ways, is to always keep that presumption in the forefront, to say, okay, this might be a gray area, there might be a gap in the law, but what errs on the side of transparency? And when you do that, even when claims are filed, because as an enforcement mechanism, people can go to the AG's office, they can go to the local DA, and typically those enforcement agencies are going to look at, look, was this really an attempt to circumvent the law? Or was this just a gap in the law and a good-natured, or good-intended interpretation of the law? And I think that makes a big difference as to whether they go to prosecute that or not. So something to keep in mind. The last things I want to talk about then are under miscellaneous. So I'll run through them quickly. Attendance in closed sessions of government body. I often get asked who should be in attendance. Bottom line is anyone who is necessary for conducting the business at hand. So that may be attorneys like myself. It may be certain staff members, members of administration, who are going to help inform the board about a certain topic or provide guidance. But really whoever's necessary for the business. And typically not people who aren't necessary. They should be excluded. Certainly if someone is the subject of the closed session, they might come in to answer questions, but generally deliberation on that issue is going to exclude them. Secret ballot votes, no secret ballot votes unless you're talking about your reorganization, in which case that's permitted. Use of equipment in open session, this is an important one we just saw in the news recently, where people, whether it's media or members of the public, have the right to record, whether that's audio or video, any open session of a meeting. The key is they can't be disruptive, right? So they can't set their camera up, between you and me. They can't disrupt the board in a manner that they can't conduct its business, or make loud noises, or block the entrance, or things of that nature. But otherwise, they have a right to do that, and the statute expressly states that we have to accommodate that. So something to keep in mind. I talked a little bit earlier about task force committees. Just remember that just because a committee might be advisory in nature, or doesn't have decision-making authority, doesn't necessarily mean it's not subject to the open meetings law. It's a very, very fact-specific analysis. So if you have questions about, a parent advisory, community advisory task force, for instance, that you see a lot in a lot of districts, that's something you should consult with legal counsel over, because we'll have to look at, why and how was it developed, who developed it, was it done by rule or order, like we talked about earlier, to the extent that it's going to be a governmental body that's subject to the open meetings law. And then the last thing I want to talk about is just enforcement and penalties. So as I mentioned, the AG's office and the DA's office are both ways that individuals can file complaints, and those can either be pursued by those entities, or an individual or private citizen can pursue it as well. There's a 2-year statute of limitations on that. You fines anywhere from $25 to $300 for each violation of knowingly attending a meeting that's not properly noticed, or that's in a closed session that shouldn't be in a closed session, things like that. If you have a question about whether or not something has been properly noticed, or if you should be going in closed session, those are the things you consult with administration on, because they're going to have that access to legal counsel. They're going to have that background where we can analyze it and determine whether or not this is something that's appropriate, and how we post it in order for the board to be able to discuss what it needs to discuss and meet its obligations for transparency. And that's what I have for tonight. Are there any questions before I go?
The only thing that I just want to reiterate is under your public comment during open session, you listed we can't engage and we can't discuss what the citizen has come to talk about because it's not on our agenda. And as a board, that also means we can't go off our agenda. So it's kind of a frequent thing that it's attempting to do it with open comments, but as a board, we have to stick to our agenda.
Yeah, and it's really tough because in a lot of these situations, you have to balance as elected officials your desire to be responsive to your constituents and engage with them, and at the same time, honor honor the requirements under the open meetings law that say there's a time and a place to discuss things. And that can be challenging for board members, especially when the public comments might be heated or misinformation's provided. I mean, I have seen circumstances where instead of just saying thank you for your comment, there is a level of engagement as far as providing information. I'm not saying that can never be done, but best practice is to just not engage. If there's misinformation that needs to be corrected, it can be done at a later time, either with that individual or perhaps with a public statement if it's that high profile. But really, I've never seen a lot of good come from anybody trying to engage a public commenter in an open session.
So adding to that, public comment, if they are asking about things that are on the agenda, is that something that can be discussed by the board?
So I think you're safer there, yeah, because you're not required, I still don't advise getting into back and forth, but for instance, I mentioned providing information, right? So if someone makes a statement about something on the agenda or asks a question, generally you wouldn't engage, but there are rare times when the board president might say, or administration might say, I need to provide the information. I'm going to answer the question. The question's simple. I know the answer. I'm going to answer that question. And if it's on the agenda, I think you're fine because the board is not required to stick to the order of its agenda. So I don't think you'd have a technical violation, but it's a slippery slope, right? I mean, as soon as you start answering questions, people will say, well, you answered her question, why not mine? And now, and then you get the ball rolling with a lot of questions, and it doesn't lead down a good path.
Right, but I mean, we have, wherever it is here, actually it's over by the little check-in. I mean, so there's a check-in where we actually have a set of little guidelines in terms of for public comments, and it would be addressed in terms of what we can address and not address during the course of the meeting. So hopefully that little brochure has that information in it, so.
Yeah, and I don't know what your experience has been in the past, but I deal with some boards where if things are very political, you'll get public comments that get pretty heated, pretty on the edge, and even passing over the edge of good decorum, and it can be tough. It takes a really strong hand for the presiding officer to be able to handle those kind of situations. And again, I like to fall back on policy, on statements under the agenda, on things that have already been established, so you try and minimize those on-the-spot determinations. So the best example I always give is the presiding officer shouldn't have to make determinations, or shouldn't make determinations on the spot as to whether or not somebody's speech in a public comment period is defamatory, right? I mean, there are legal elements involved in that. There's a whole analysis, and you start restricting speech because you don't like that the person's attacking a public official or even a public employee that has a very high bar for scrutiny, and I think that you're going to expose yourself to substantial legal liability.
Who can? Public comments. Do you need to be a member of the district anybody can attend, but to actually make a comment, do you need to be a member of the district?
It's a great question, and it is one for a long time that I think was answered by saying if the board wants to regulate that, they can. Recently, we've seen a number of cases, all of which I'm aware have been settled, but a number of cases in Wisconsin that have challenged that. And I think that there is kind of a changing of the tide in interpretation of the law to say, you need to be careful about who you exclude. And I'm not saying you can't do it. In fact, in my experience, most districts do it, right? They come up and they say the person ask the person to state their name and their address. But I think if you're going to do it, it needs to be narrowly tailored so that you capture parents, right? I mean, what about a parent of an open enrollment student? They've got to be able to speak. They're a stakeholder, arguably, that they should be able to speak. What about staff members?
Right, well, they have connections to the district. That would all fall into that
Our
category.
policy specifically lists those groups.
Yeah, and so I think that's a safe way to do it, or safest way to do it, is to identify who are the stakeholders and allow them to speak. I think you're going to minimize. But I had one case that did end up settling where you had a journalist from another state who wanted to make online comments. There was dispute over whether or not the law allows you to shut somebody down or not let them comment simply because they're attending virtually from elsewhere.
What is the purpose of putting your name and address on these forms if not to let the board know that they are in fact able to actually ask a question?
That is the purpose. Yep, that's the purpose. And so boards who require that you be a stakeholder, they typically require that you demonstrate that by coming to the podium and identifying who you are and where you live, or what your connection is to the district.
Thank you.
Anything else? Great. Well, it's been a pleasure joining you. Thanks.
Thank you, Brian. Appreciate it. Thank you.
All right, so moving on, we're gonna move on to the consent agenda. So we're looking to accept minutes from the previous meeting. Minutes from May 19th meeting, regular meeting, and the policy committee meeting, as well as the business affairs meeting all on May 19th. Accepting correspondence, which was in our packet, and gifts, but there was no gifts this time. I have a motion to accept the consent agenda.
I move to approve the consent agenda as presented.
Second.
All in favor?
Aye.
Any opposed?
Oppose.
So we're moving on to the Business Affairs Committee. So Stacy is gonna give us a report from the meeting that was held earlier.
All right, we went through the financials. Due to the time of year that we're at, the revenue stream is still at about 60% of budget. Our expenditures are at about 80%. We will anticipate receiving the last of our revenue stream of $7.5 million in August with the property taxes. We talked about the capital projects and John gave us a little update. I'll give a little bit of an update, John, about where we're at with things. The phase one, the fitness center, targeted occupancy is August 4th. The CTE wing, August 7th. Is that right? 3 days later?
No, the CTE wing tentative is December of 2026.
Sorry about that.
Got the wrong date, Brenda. Culinary is what date?
Culinary will be
Doubting
ready the
myself.
first week of August.
Oh, I had that one right, okay. And then the life skills, which is the old culinary, early August as well. John went into a discussion about some cost-saving measures, highlighting kind of the 3 or 4 top expenses that we have, which is our staff expenses, our health insurance, transportation, and utilities. And John, being John and his team, they are working very hard to manage all of those. The biggest one probably that we're seeing the cost savings is our self-insured insurance. It's performing as expected. We're hoping to, at the end of the year, have saved 1.3 to 1.5 million over the prior year for that. So that's kind of my high-level summary. John, do you want to add anything?
I think you hit on the big ones. That was a significant impact by revamping the insurance plan and the delivery model that we had for the staff this past year, and really had a significant impact on what our projected cost were going to be for 24-25 and performing as it was projected.
There are no questions. Can we get a motion to accept the business affairs report as presented?
I move to accept the business affairs report as presented.
Second.
All those in favor?
Aye.
Any opposed?
Oppose.
Moving on to the policy committee. So in the packet, it was the first reading of the following policies. So we had 6500.10 technology acceptable use, 6700.01 graduation requirements, 3200.01 purchasing and bidding, 5200.09 high school alternate education, and 3900.01 release of public records and property. I didn't receive any questions about anything, so I don't know if anybody has any questions about any policies, changes. If not, motion on this?
No, this is first read, so this is the opportunity to discuss it, and if there's no questions, then it moves to the next meeting for approval.
Moves on, and then we'll move on to new business. So we have the teacher on-call contract renewal, which is John.
So in your packet, you have the proposed renewal for the 25-26 and 26-27 school years with Teachers on Call. They've been our provider of our substitute services back in 2012-13, in that range. We moved from employing all of the substitutes within the district to utilize a service to broaden our access to substitutes when we needed them, and has outperformed the contract that we have with them. The fill rates on our teacher group this past year, were over 99%, and the fill rates overall over 97% for positions that we've had. We're one of the highest ones. And I mentioned Colin Jacobs does a great job of working with Teachers on Call to ensure that we are an attractive place for the substitutes to come to work. We work real hard at being welcoming and receptive to them in the buildings and helping them out, and the subs really appreciate that, including some additional training on classroom management and expectations that we provide for them during the summer. So the recommendation then is to approve. The rates are the same that we have had in the past for the substitute contract with Teachers on Call.
Anybody have any questions or discussion?
What are the rates, John?
So we have three different rates for substitutes. Our base rate is $125 per day. The second tier rate for people who have had longer serving relationships, I want to say is $140, and then the rate when you're in a long-term subbing position was $165 a day. And then we pay a percentage on top of that to Teachers on Call to manage all the staff, provide benefits, provide all the other responsibilities for the contract.
What is the percentage?
I believe it's 29% right now. I'd have to double check that.
And that's 29% of what? Of their
Of the pay rate.
Okay.
Correct.
Has it always been that? That's high?
Yes. The initial contract, I believe, was 24%, like 10 or 11 years ago. And then the the offerings from the company were enhanced to include potential health insurance coverage and other benefits for the staff members, which then pushed that rate up.
Do they work for Teachers on Call?
Yes.
They're employees for them?
Yes.
And that's it. Thanks.
Any other questions or discussion? Not, then I will seek a,
One more question. Sorry, Ash. They're employed by Teachers on Call, and they're not employed by us, and we're paying, it looks like everything we would pay if they were employed by us. Could you dive into that a bit?
Depending on we would pay if they were our employees, depending on the hours and the amount of time that they worked. We would be paying, in addition to the rates we would be paying for retirement, for the district portion of retirement, about 6.3% of the salary. We'd be paying health insurance for them if they were employed by us, and they met the thresholds of the time of service within the district. Plus then managing a substitute pool of 200 to 300 additional employees, who would be adding about 60% to the number of employees that we have within the district.
The 29% includes everything except the last item?
Except for what, by the last item, what do you mean?
That you just went through a number of things that if.
That and a number of other cost management costs, yes.
The cost management was the last one,
Yep.
is what I'm referring to, okay.
Yeah, I would probably have to have additional staffing allocated. For sure, we would have to manage those. I mean, if you go way back, it was probably additional secretary time in every building, or they have to have additional hours to come in early to make all the phone calls. You also have to have recruitment strategies in place to have a stable of substitutes. And also, like, for example, one of the things that's a benefit of going through Teachers on Call, so if we have teachers who retire and then want to sub, they're not, with the current rules around the pension system, we wouldn't be able to employ those former teachers. But they can sub because they're not our employee. They're teachers on call employee because they can work anywhere, but they may take assignments here. So there's a variety of things that are really make that extra beneficial. But those are really good questions, Mary.
Thank you.
I will seek a motion to approve the teacher on call contract renewal as presented.
So moved.
Second.
All those in favor?
Aye.
Aye.
All those opposed?
Oppose. Thank you.
Next, we're moving on to employee handbook and addendums.
Well, John, you can jump in too. I make some comment here. You have a number of materials there. This is always really important information for the board, and what we try to do is summarize just the changes that were made over previous years, because obviously there's an awful lot of content in the handbooks and the addenda. The summary memo from Dr. Jacobs walks through those different pieces, and I'll just kind of give you the nickel tour of what's in there for sake of conversation. Employee main handbook, you can see there were some changes to the district technology use section. There are some pieces there, including employee use of email. That was a component of that. There were some items there on personal appearance staff dress code that were addressed on page 38. There were some items there under the administrator addenda regarding the FSA account and maximum amounts that are there that reflect the IRS limit. Teacher addenda, there were some items there of specific note with the teacher general leave provision. We had talked in the past here about a proposal that we brought forward that we shared with this board a couple of times of moving from where we had 10 sick days that accumulate each year combined with 2 personal leave days to try to create more flexibility, which is coveted by the staff. So this reflects a move from 10 to 9 sick days, but 3, what are we calling them? General leave days. I think in the past we'd refer to them as paid time off days that give teachers more flexibility to be able to access time off. And there's guidelines in there that define how those may be used and how a rollover provision would be managed. So that's a notable shift that's really a benefit that as we've went around and talked to staff about that was pretty popular. In addition, clarifying language added to the wages on pages 3, that's into some of the extra duty supervision items there, and chaperoning. Medical FSA maximum, was that because of an IRS piece?
Yeah, it's the same. FSA maximum amounts from $3,000 to $3,200 for the calendar year.
So you see that in a number of addenda. So any employee group that affected is in there. Paraprofessional addenda includes that piece as well, secretary as well. So that's kind of the high level review of the changes that were made, but we're happy to take any questions that you have.
I was really happy to see that change in the PTO sick day. I think that's great and so responsive to the staff and what they've asked for.
Yeah, that's flexibility is something that we hear all the time, and you know that life happens and the ability to go and handle things, and you know you don't want people in a position where they feel like they've got to use sick leave, maybe that inappropriately, or have approved quite a bit of unpaid leave for things, and that's not the greatest situation either for staff. You know, their child's getting married and they have to take unpaid leave. If they can plan ahead and roll some days over, it allows for them to kind of plan for it, and I think this is a benefit that'll help with our retention goals that we have with workforce development.
Any other questions or discussion? If not, then we'll seek a motion to approve the employee handbook and addendums as presented.
So moved.
Second.
All those in favor?
Aye.
Any opposed?
Abstain.
property and liability insurance renewal consideration and possible approval.
So tonight at the meeting, we will take up the liability side of the insurance renewals for the district. We have taken the property coverage back out to the market and are looking at some analysis right now of policy alternatives that are coming in and waiting for some responses. So at this point, what we do annually is we assign lines of coverage to different brokers that are available, so that they're not all approaching the same markets, the same carriers. And they will come back with a proposal for us for the policies for the year. Those policies are analyzed to make sure that there's no dramatic changes in coverages for the district. Then we make a recommendation going forward. M3 has been the broker who has carried our liability lines for several years, and we're recommending to move forward with a renewal with them for the policies which include our general liability, our employee benefits liability, violent event liability, auto liability, public officials and employment practices liability, umbrella policy, liability, environmental liability, workers' compensation, cyber liability, and identity fraud. In total, those gross policy amounts of premium are about $255,570. From that, we will receive a dividend. This includes a 15% dividend, which is payable at the end of the policy term upon audit. So a year from now, we would see that dividend of 15% of the workers' compensation. M3 has been, like I said, a long partner with the district and has done a very good job working with EMC as the primary carrier, but also other carriers as they come into the marketplace for the other lines of coverage, which are all included within your materials.
So is there any restrictions on getting that 15% dividend? You said there's an analysis of workers' comp?
Yeah, so what happens is you pay the premium, the estimated premium based on our estimated payrolls for the year. At the end of the year, there's an audit done to figure out what the actual payrolls were, and that premium is adjusted, and then the dividend is payable based on that actual premium or actual payrolls that were paid, based on the class of workers.
Are you insuring, go ahead, John.
And the rates that you're paying are set by the state, the workers' comp rates. So.
Thank you.
So the 15% is based on, the reason that it's determined at the end is because the amount it's based on changes.
Actual premium.
Because you don't know the actual right now, you'd only have an estimated. Got it. Okay.
Are you insuring, what are you using the term payroll for? Are you insuring payroll?
Workers' comp premiums are based on a rate that's set by the state, and that rate is attributable to the total payroll amount that you pay in each one of the categories.
Under all of the categories?
Under all of the employment categories.
So you are insuring payroll,
Yes.
standard payroll? Okay. Are you coming back to us on the property
Yes.
side?
Property
Okay.
will come back on June 23rd.
Thank you.
Any other questions or discussion? If not, then I will seek a motion to approve the insurance renewal with M3 per the attached summary of coverage proposal in the amount of $255,569 gross.
So moved.
Second.
All those in favor?
If I could,
Sure.
before you, why do you insure payroll?
Workers' compensation is a mandatory coverage, and it's based on the amount of payroll. You're not insuring payroll, you're providing workers' compensation. In the private sector, it's not a predetermined premium. You pay based on the payroll every time you process it. In the public sector, we pay based on a rate that's established by the state, and it's attributable to the payroll that you pay in each category. So the categories, general employees, the vast majority of our staff are in there. There's some categories that fall outside of general, like food service, drivers, we don't employ drivers, but they fall in a different category.
Are you paying, that didn't help.
Payroll is
I understand payroll, and you can insure payroll.
You're not
And that's
insuring
not what you're doing,
payroll.
you're insuring,
You're not insuring payroll, you are insuring the staff for workers' compensation coverage in case an accident or injury occurs while they're in the course of their employment in the district. The amount that you have to pay is based on the payroll that is generated.
You are insuring the payouts that come under the umbrella of workers' comp.
Yeah.
Got it. Thank you. Thanks, Ash.
Have a motion
In a second.
and a second. So all those in favor?
Aye.
Any opposed?
Abstain.
Moving on to calendar.
Yeah, why not talk about calendar again? All right, so, went back and with this one change to the 25-26 calendar, you know, this was kind of the one sticky issue. Again, just to kind of give the nickel tour here, elementaries, it's 1,050 hours. High school, 7 through 12, it's 1,137 hours. That's the first thing you have to make sure that you're accommodating. So that's a consideration. We know that we can't start before September 1st by state law, those kinds of things. We have a 190-day work calendar for staff. We typically have 178 student contact days. All those things, you kind of come together and look how the calendar lays out. And we know that there is, for parents and for staff, there's a strong desire to try to be out that first week of June. So this calendar was doable without having to do anything like add extra minutes and those things. But the sticking point was the return from winter break for just that Friday, January 2nd. That did create an abnormally short winter break, which I would say averages about 11 days. This would have made it 9. We wouldn't have expected probably our top attendance day to be on one day for our families coming back. So anyway, we looked at it again, then we worked with John's office just to recalculate all of the contact hours. We determined that we felt comfortable with the capacity, because we always want additional capacity in student hours. You do not want to be right up on that number because you never know what's going to happen. That's going to require you to close. So this would allow for about 15 extra hours in the calendar for those 7 through 12 students. We typically do virtual days if we do like a snow day for kids in the middle and the high school, to kind of preserve those, because I never know. Even in May, June, you could have an emergency closed day that could be not reasonable to try to run virtual learning. So that's why, you know, if this comes up next year and there's a snow day, why can't we just let the high school kids have a day off? It's because we're trying to preserve those hours. So at any rate, we think about all those things. We looked at it and determined that it was probably best to eliminate that January 2nd day. We recognized we didn't feel we had to add any instructional minutes, but we always want to make sure we maintain that 190-day work calendar for staff. So the solution to that, and it actually really kind of works out because we have some trainings that we want to make sure we get in for the upcoming school year. We have something called Parent Square, which is a new technology tool that we're going to use for parent communication that we think is going to be a real improvement, but that's going to require some training for staff. We have a new data tool that's going to empower our staff with the ability on the user end to make more flexible use of data. Some of those things, not a huge amount of training, but all those things are pieces that we want to get done. So that we added a day to the teacher in-service, which used to be 3, this year would be 4 days. At any rate, I know this was all in your memo. So, long story short, we're looking for your approval to make that change of eliminating the January 2nd day. So we would be at 177 instead of the typical 178 for students, but we still would meet hours, and then add that 4th day of in-service for teachers. So I'd be happy to take any questions, otherwise I'd seek your approval.
I do want to say that I very much appreciate the hard work that you put into the calendar. And I know I bother you about it a lot, but
Well, you know,
there's a lot of parents that appreciate that, just having that extra day.
It's one of those fun items that seems like we can never quite get it perfect. And, you know, there's always going to be someone who would rather have this day than that day, but I do recommend this change. I think it's definitely an improvement.
So, okay, Mike, I hate to repeat this out there. So we have a published 2025-2026 calendar for families, and we had this one that was attached to the meeting tonight. But in that middle section, and you said, oh, we're going to have high school graduation on May 30th, but the document does not say May 30th in terms of high school graduation. So either these documents are not correct, and I'm reluctant to approve a document or a calendar that doesn't have that official graduation day in there. I mean, unless we're gonna. not
Well, the
have
date,
that.
the date that Brian and I just talked about it this week, dates like that, generally what the board's always acted on is the days we're in session through the school year. Some of that's content in the middle, gets adjusted from time to time without necessarily having full board action. But yes, in consideration of your vote, May 30th, which is Saturday, which would be a date like we had this year,
Okay.
is the planned graduation date. The previous calendar had June 5th, but that again is conflicts with WIA events that we want to avoid. So as a part of the presentation, I would say that was just a detail we forgot to change in providing you the calendar.
Calendars will also include
The parent will include a May
an
30th
adjustment
graduation.
for the May 31st.
Correct.
Because, yeah, on here it's just listed, and it looks like it's associated with June 5th. So you have half-day, last-day, high school commencement. So you will put in a line item for May 30th.
Yes, we will.
Okay.
Yes, we will.
On both calendars.
Yes, we will.
So then I move to approve the amended calendar as presented, so.
Just a quick question on that.
Yep.
Will the high school and ASA also be getting out on June 5th? Even if,
With the exception of seniors. Seniors will graduate, like this year, seniors were done the week prior.
what about eighth grade?
They'll be done May 5th.
June 5th.
June 5th.
Okay.
For
so
June
they have
4th, it's
promotion.
Wow, they really got out early. No, June
4th is on the calendar here.
June 5th is but that
Promotion.
they'll do,
The
but they,
promotion.
just same thing this year. They do their promotion ceremony the night before, but they still have the items on that last day, and this year was the 6th, that year would be the 5th. Yep. So just seniors get done early.
Okay, so we have a motion.
Second.
All those in favor?
Aye.
Any opposed?
Abstain, I'm worried about the date change. Want to make sure it sticks.
Moving on to personnel issues, so we have some resignations.
Correct. Let me get to the right item here. Yes, we had 2 resignations. Asa Clark, special education teachers Annie Bolin and Jessica Kraft. I'd seek your approval.
Can we do both of them the same?
You can do them together.
Move to approve the resignation of Annie Bolin and Jessica Kraft as presented.
Second.
All those in favor?
Aye.
Any opposed?
Abstain.
We have some employments.
Correct. So we have 3 employments. 2 are replacements. 1 is an addition that was part of the staffing plan presented for adding a special education teacher at PLE. Andrea Daniels, the recommendation is a hire to replace Annie Bolin, whose resignation you just approved, and Everett Harmelink, grade 7 ELA teacher, to replace Ryan Surfort, who's moving off to Paris with his family. So I would seek your approval for those 3 hires.
We need a motion
Okay,
to,
move to approve the hiring of Andrea Daniels, Stacy Mana, and Everett Harmelink as
Second.
presented.
Second.
all those in favor?
Aye.
Any opposed?
Abstain.
To board goals and operations. So upcoming activities, we have Wednesday, June 23rd is our next meeting. Just a regular board meeting here, and so just as a reminder, all meetings will be held here throughout the summer. The next meeting after that, which we have a date change from July 14th to Monday, July 21st.
I'll be gone the 14th, so
Okay.
I appreciate the flexibility of moving that to the 21st.
That will include business affairs and policy committee meetings at 6 and the board meeting at 7. And then Monday, August 18th, we have our annual meeting, which is going to be in the PHS auditorium. We will have the business affairs committee at 6. We will have the board meeting starting at 6:30. The budget hearing will be at 7, and then the annual meeting will be at 7:30. Monday, August 18th, we have the new teacher orientation from 7:30 till 9 a.m. And that'll be in the PHS Commons or the auditorium. And then we have breakfast with the board from 9 to 10 in the ASA cafeteria. And then Monday, August 25th, we have the welcome back breakfast in the cafeteria at 7:30 with a program to follow, and then we need to hold for a special meeting to possibly consider any hires at 7:15.
There was the July 11th through 12th WASB Summer Learning Symposium. Just if anybody's interested in that one, just let Tammy know. She can help you if you're interested in going up to Stevens Point to attend that.
We did get our Board of Education meeting calendar and our packets for the next school year. Board of Education evaluation survey discussion, board meeting results.
Yeah, so this is the self-evaluation that you do in regards to the functioning of your meetings.
I just have a question on this one, Mike. Given that Brandon's not here, I don't know how much we want to discuss that particular topic.
Yeah, you might want to just bring it back,
Yeah.
put it on for the next one, that would be fine.
What's that?
I'm missing the next meeting.
You could move it to the July meeting for that matter.
I mean,
If everyone will be here at the July 21st meeting.
whenever the next meeting you're back, whenever we're all here again,
Yeah,
I think it's important to everybody to be a part of
I
it since
agree.
it's a survey, so.
okay.
Makes sense.
So we'll table that and talk to Brad about that.
You have that, Tammy, move that to the 21st.
And any legislative updates?
Well, I think things are suddenly moving fast and furious here. What we're told is that the Joint Finance Committee plans to vote on Thursday on education-related items. I did reach out to Representative Nalen and Senator Hutton today just to see if we had one more opportunity to get on a call with either or both of them, just to kind of hear from them what they're hearing in terms of some of the details of that. We've heard some different things, and then to be able to provide them with information as to how some of those items would impact the Pewaukee School District, so they would have that as our representatives. So we're endeavoring to, and we've met with both of them before, but before decisions are made with that vote, we wanted them to be able to understand how some of the things might impact us. So things are moving pretty quickly in that regard. If it comes through joint finance, then go to the full group, and then if they pass it, presumably, which they would go up to the governor, and then we'll see what he does with it. There was that a week or two ago, where they kind of broke off negotiations. So I know everybody's super surprised that they weren't able to come to an agreement and compromise. It's a little frustrating. I wish it were otherwise, but that's typically how things have went in recent memory. So, but that's kind of where we're at. So there could be a lot happening this week. I don't know, Larry, if you have. Yeah, I know you were just up with the WASB board.
Yeah, but we
in Madison.
didn't really talk a whole lot about what the budget was there. But I think one of the things that is coming through is, I think that they heard and understood some aspects of the special education funding that, again, all of the groups out there have asked for and need, but now they're kind of like playing games with it maybe in terms of looking at it from only the high cost special education versus special education across the board. John, is that your understanding too, that that's how they're potentially looking at it to increase the high-cost special education funding, but
Yeah, the high-cost special education funding, there's a couple of different things that are coming through in the last 24 hours that I've seen coming through, and not just a focus on special education funding as a whole, but like you said, that high-cost portion of there. Put it into perspective, the pot of money that is allocated for special education aid reimbursement in the state is about $574 million. The pot of money allocated for high-cost special education for those high-cost, low incidence, high-cost students is about $14.5 million. So significant difference of adding to the percentage that's reimbursed on either of those. There's a significant difference in the investment and the impact that would have on available resources for districts.
and then the other topic that's out there too, there's the tax levy credit that they're talking about increasing that a whole lot, but that does not produce a single penny or dollar or nickel or dime for school districts to spend. It goes into a tax levy credit, so, but it doesn't give school districts anything, right?
It depends what it's coupled with. So in the last biennium, we saw the low revenue ceiling go from 10,000 to 11,000.
Okay.
Increasing $1,000 in your revenue limit per pupil generates a significant tax increase. The dollars going into the levy credit are an offset to what that increase would be in your taxes. The transparency is the argument on all the time, because the district levies the full amount. You pass a levy that's the full amount of your calculated revenue limit levy. The property tax levy credit is a credit that is given to the municipalities from state funds for education that they reduce on the property tax bill. So the district may publish a 5% increase in your levy. In reality, majority of that increase will be offset by the increase in the levy credit that does not reflect on our books ever.
Right, but does that also then, if how what you're explaining it though, John, so rather than take the money out of the state's general fund, it kind of puts the burden back on the local school districts to increase their tax levy rates, right? So,
Yeah, the levy credit is part of what used to be considered 2/3 funding for schools.
Yeah.
It's part of funding for schools, but it's not transparent. It doesn't appear on our ledger ever.
right, but it would, I mean, if we are allowed to increase our, whatever it is, the revenue limit, that comes back to local taxpayers, right? Rather than coming out of the state's general fund, which they collect all the income taxes and all that kind of fun stuff, so.
In the high-cost special ed piece they're talking about would not do much for,
It would be negligible, right?
it will be very, it's gonna have very little impact on school, but it's gonna have very little impact on us, so it would have so if you hear about that, well, they're doing something for special ed, well, no, they're doing something for high-cost special ed, it would be
I mean, it's
not a
like-
lot of money.
You said, what, 14 million versus 574 or something, right?
Right,
So, I
so-
mean, it's a handful, maybe. of
Right, and then you
students.
disperse whatever that percent increases across, 400 plus systems, and so.
So, yeah, fun times ahead, I think, in Madison.
Yeah, we'll
for
see what shakes
people
out
over
there.
so.
All right, Tammy, any comments from citizens?
There are no comments from citizens.
Can I seek a motion to adjourn?
Move to adjourn.
Second.
All those in favor?
Aye.
Any opposed? All right, thank you.
Thanks, everybody.
Thanks.